Hello, my name is Felix Pineda. I decided to cover Nevada Department of Human Resources v. Hibbs, number 01-1368, argued January 15th, 2003, decided May 27th, 2003. The case goes, an eligible employee of the HR department of the state of Nevada, Mr. Hibbs, asked for family medical leave of 12 weeks, which was his right under Family and Medical Leave Act of 1993 in order to care for his wife who was ill. U.S. Code, Title 29, Chapter 28, Section 2612, A1 says, subject to Section 2613 of this title, an eligible employee shall be entitled to a total of 12 work weeks of leave during any 12-month period for one or more of the following. One reason listed is C, in order to care for the spouse or son, daughter, or parent of the employee if such spouse, son, daughter, or parent has a serious health condition. Mr. Hibbs took the 12 weeks to care for his wife, and at the end of the 12 weeks, he was notified that his time had been exhausted and was given a date to return to work. Mr. Hibbs failed to present himself to work on that date, and he was terminated. U.S. Code Title 29, Chapter 28, Section 2615, A1 says, it shall be unlawful for any employer to interfere with, restrain, or deny the exercise of, or the attempt to exercise any right provided under this chapter. Pursuant to FMLA provisions, creating a private right of action to seek both equitable relief and money damages, Mr. Hibbs sued the department seeking damages and injunctive and declaratory relief for, among other things, violation of Section 2612 A1C, the 12-week period. U.S. Code Title 29, Section 2617 A2, right of action says, in action to recover the damages or equitable relief prescribed in paragraph 1, which says any employer who violates Section 2615 of this title shall be liable to any eligible employee affected, may be maintained against any employer, including a public agency, in any federal or state court. The federal district court found that the department had immunity through the 11th Amendment, which says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States or by citizens or subjects of any foreign state. It also claimed that Mr. Hibbs' 14th Amendment rights, the Due Process Clause, which says, no state shall deprive any person of life, liberty, or property without due process of law, had not been violated. The Ninth Circuit reversed. The Supreme Court of the United States held. It found that state employees may recover money damages in federal court in the event of the state's failure to comply with the FMLA's family care provisions. It also held that Congress may abrogate the state's 11th Amendment immunity from suit in federal court if it makes its intentions to abrogate unmistakably clear in the language of the statute and acts pursuant to a valid exercise of its power under Section 5 of the 14th Amendment. FMLA satisfies the clear statement rule. In this case, the Nevada Department of Human Resources acted outside its scope of authority and had no immunity because it is constitutionally set that employees have the right to FMLA provisions and the state may not interfere with those rights. Thank you very much.